It's very important that you do so. I'm just going to go over things that I know, that I've seen, and that I'm familiar with from my years as a recruiter to hopefully give you a better understanding. But this is something that you really want to pursue on your own with a licensed legal representative. First is termination with or without cause, specifically without cause. With cause can be pretty self-explanatory, but usually the way it works is either you or the employer can let you go without cause. Just bye, we're done, thanks, have a good life. And usually there's anywhere from a 90, sometimes 180. If you're in academics, it can be a little bit higher. But generally, you're going to have about a 90-day, you have to stay, or they have to keep you for another 90 days when they let you go. What happens with trailing AR that you earn during that 90 days? How does the payment work out? Are there any changes in payment if you are let go and you have to work out the last 90 days of your contract? Generally, that's more of a private practice conversation. And the next is the restrictive covenant. There was a big move a while back to ban restrictive covenants at the national level. Don't be deceived. Unfortunately, that movement has died. It's done. They've withdrawn, and it's a state level thing now. Now, the good thing is, given the severity of the physician shortage, a lot of states are pushing protective clauses that allow physicians to not be constrained by non-competes. Look at what the state law is with where you're at, and more are starting to follow suit, because a physician who comes in to see patients and there's a restrictive covenant has to leave and go somewhere else. Well, sure, that might protect the employer, but ultimately those patients in the community suffer. So there is a lot more protection now for physicians than there was. You also want to know what the restrictive covenants, because you're not always going to get out of it.